Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations related to steno and steno contents. Be ready for the high speed passage. The main object of Article 16 is to create a constitutional right to equality of opportunity and employment in public offices. Stop. The words employment or appointment cover not merely the initial appointment but also other attributes of service like promotion and age of superannuation, etc. Stop. The appointment to any post under the state can only be made after a proper advertisement has been made inviting applications from eligible candidates and holding of selection by a body of experts or a specially constituted committee whose members are fair and impartial through a written examination or interview or some other rational criteria for judging the intrinsic merit of candidates who have applied in response to the advertisement made. Stop. A regular appointment to a post under the state or union cannot be made without issuing advertisement in the prescribed manner, which may in some cases include inviting applications from the employment exchange where eligible candidates get their names registered. Stop. Any regular appointment made on a post under the state or union without issuing advertisement inviting applications from eligible candidates and without holding a proper selection where all eligible candidates get a fair chance to compete oblique complete would violate the guarantee enshrined under Article 16 of the Constitution. Stop stanza. Thus, it is clear that adherence to the rule of equality in public employment is a basic feature of our Constitution, and since the rule of law is the core of our Constitution, a court would certainly be disabled from passing an order upholding a violation of Article 14 or in ordering the overlooking of the need to comply with requirements of Article 14 read with Article 16 of the Constitution. Stop. Therefore, this court, while laying down the law, has necessarily to hold that unless the appointment is in terms of the relevant rules and after a proper competition among qualified persons, the same would not confer any right on the appointee. Stop stanza. It was further observed that it has also to be clarified that merely because a temporary employee or a casual wage worker is continued from a time beyond the term of his appointment, he would not be entitled to be absorbed in regular service or made permanent merely on the strength of such continuance. If the original appointment was not made by following a due process of selection. Stop. It is not open to the court to prevent regular recruitment at the instance of temporary employees whose period of employment has come to an end or of ad hoc employees who by very nature of their appointment do not acquire any right. Stop. High courts acting under Article 226 of the Constitution of India should not ordinarily issue directions for absorption, regularization, or permanent continuance unless the recruitment itself was made regularly and in terms of the constitutional scheme. Stop. The question of regularization of the services of such employees may have to be considered on merits in the light of the principles settled by this court in the cases above referred to and in the light of this judgment. Stop stanza. In that context, the Union of India, the state governments, and their instrumentalities should take steps to regularize as a one-time measure the services of such irregularly appointed who have worked for 10 years or more in duly sanctioned posts but not under cover of orders of courts or of tribunals and should further
ensure that regular recruitments are undertaken to fill those vacant sanctioned posts that required to be filled up in cases where temporary employees or daily wagers are being now employed. Stop. The process must be set in motion within 6 months from this date. Stop. We also clarify that regularization, if any already made but no subjudice, need not be opened based on this judgment, but there should be no further bypassing of the constitutional requirement and regularizing or making permanent those not duly appointed as per the constitutional scheme. Stop stanza. On behalf of the petitioner, it is contended that the order of the District Inspector of Schools is patently misconceived. Stop. An order of suspension passed against a teacher principal of an intermediate college cannot remain in operation after 60 days unless it is approved by the District Inspector of Schools in writing. Stop. Such approval of the District Inspector of Schools does not in any way take away the power of employer to withdraw the suspension at any time for valid and good reasons. Stop. It is submitted that under the statutory provisions applicable, there is no requirement of any approval being obtained from the District Inspector of Schools before recalling the order of suspension by the appointing authority. Stop. So far as the second ground mentioned in the order is concerned, it is submitted that the petitioner was suspended under an order of the manager himself and therefore such order has been withdrawn by the manager. Stop. The suspension was not effected under any resolution of the board and therefore the complaint of 2 by 3 members of the board that no decision has been taken to withdraw the suspension is neither here nor there. Stop. It is also pointed out that the order of the District Inspector of Schools approving the suspension dated 29/1/2010 has not been communicated to the petitioner till date nor any opportunity was afforded by the District Inspector of Schools before approving the same. Stop stanza. Shri V.K. Singh, advocate on behalf of the officiating principal, contends that the petitioner did not challenge the order of suspension affected against him nor the order of approval. Stop. It is stated that the issue as to whether the earlier suspension was effected under a resolution of the board or not has not been raised nor has been gone into under the impugned order. Stop. He points out that the petitioner is involved in criminal case under section 420 IPC as is apparent from the copy of the first information report enclosed along with the writ petition. Stop. With reference to the judgment of this court in the case of Brij Raj Swaroop Bhatnagar versus District Inspector of Schools Ghaziabad and another 2001 within bracket 4 ESC 1574, it is submitted that such a principal should be kept out of the office. Stop stanza. Lastly, it is contended that once suspension has been approved having regard to the seriousness of the charges, the Committee of Management could not have withdrawn the same unless the charged employee was finally acquitted of the charges levelled. Stop. The finding recorded in the impugned order by the district inspectors of school that suspension order cannot be revoked once it is approved by the District Inspector of Schools under Section 16 of the Intermediate Education Act without his approval is legally not correct. Stop. Under Section 16 of Act, the power to suspend the teacher principal is with the Committee of Management. Stop. Power to do an act includes with its ambit and therefore the appointing authority which has placed its employee under suspension can always withdraw such order of suspension for valid and good reasons. Stop stanza. So far as the second part of the order is concerned, there is serious debate between the parties as to whether suspension was effected under a resolution of the board or not, and therefore withdrawal of the same is also require a resolution of the board itself or not. Stop.